a comprehensive and persuasive consensus, you're often driven down to lowest common denominator solutions if you want to rely on that process to generate a universal view about what ought to be done. And the last condition is dynamism. Why does that matter? Why is technological dynamism important? First, it blurs all of these jurisdictional boundaries with respect to disciplines. That means that more public agencies on any single issues will claim to play. They'll say, we're tenants in common, we're in this domain, and you don't oust us through your individual decisions. And second, as much as agencies like to say, yes, yes, we're bright, we're expert, they are, the fact of rapid technological change puts extreme pressure on the joints of agencies that depend upon a deep knowledge base to make a good diagnosis, much less to come up with good solutions. Why is the FTC an interesting example? The 1914 design made it a scalable, adaptable convener to perform a consultative function and to assist in promoting consensus. And there was an early recognition through the FTC's work decade by decade that it had to rely on contributions from what Alan Fels has called co-producers, academics, business groups, advocacy groups, professional groups around the country to assist in forming the base of knowledge and implementing policy over time. In the area of privacy, for example, the FTC over time has performed the convening role quite a bit. I just sharpen a little bit Danny's characterization of the development of privacy. I agree that ultimately the privacy commands have come out of public institutions, but there was a massive period of consultation that the FTC used through a variety of devices to inform what those views would be, to make them more legitimate and effective. Many of you participated in that process. So the stakeholder consultation was intense and expansive. Let me finish with an example that shows both the promises of the broader consultative process, but its pitfalls. And this is, in the area of competition law, how do you form a sense of international consensus about norms? Norms in academic speak are not binding rules. They are ideas about how people should behave, but they often, when they are widely adopted, provide precursors for what become binding rules. When people opt into norms, it's a form of dating, in effect. If they become comfortable with the norm and standard, it's a short step to saying, let's impose it as a mandatory requirement. There were pre-existing networks for competition law where we've gone from 20 jurisdictions in 1990 to about 125 today. That is a staggering growth in a period of barely 20 years. One was the OECD. They were there. What was the problem? Too rich, too small. Largely rich countries. They made efforts to bring in others as observers, but this was seen as the rich person's club and all government-to-government relationships. What does that mean? If you go to the OECD,